The Subcommittee on Workforce Protections will come to order. I note that a quorum is present. Without objection, the chair is authorized to call a recess at any time. The subcommittee is meeting today to hear testimony on the Department of Labor's wage and hour division's policies and priorities. Good morning, everyone, and welcome to today's hearing. The committee convenes today to execute its constitutional responsibility to provide oversight of the executive branch. Upon taking the oath of office, President Biden pledged to his administration to the highest standards of transparency. We plan to hold him to his word. However, Ms. Lumen, one glaring constitutional anomaly at your department, the Department of Labor, must first be addressed. After 337 days, the person purporting to lead the department, Acting Secretary Julie Su, remains an unconfirmed secretary. This has created an embarrassment to your department and a crisis of legitimacy with respect to every rule and regulation it churns out. It is an insult to the members of the United States Senate who carefully considered Ms. Su's nomination for months, who met countless times with Ms. Su and administration officials, who were on the receiving end of a war room set up by the Biden administration, only to be told it was all play acting, that the administration could care less what the Senate thinks or what the Constitution requires, that the president was going to simply install his preferred secretary without the inconvenience of a vote, even if it happened to be the least qualified person in the country for the position. On April 26, 2023, I, along with leadership in the House, called on President Biden to abandon his failed nominee. On July 21, 2023, unconfirmed Acting Secretary Su set a record for time spent in Senate purgatory. That was quite a while ago when she set that record, July 21st, 2023. She became the longest stalled nominee ever while her party controlled the Senate and White House. On January 4th of this year, I wrote a letter along with Chairwoman Fox making a common sense request to the president that Ms. Su not be renominated to a position for which she had already been rejected. Unfortunately, 4 days later, she was. Unconfirmed Acting Secretary Julie Su has now nearly tripled the old record for a stalled nominee. Her presence at the helm of labor refutes any notion that the president planned on running a transparent administration. Today, I am once again calling on President Biden to remove unconfirmed Acting Secretary Su from her post. Each day her dubious tenure lasts is another day the American people are denied a legitimate leader of a massive taxpayer-funded department and are denied a secretary who is actually on the side of American workers. You see, there's a reason Ms. Su faced bipartisan opposition in the Senate. Not only did her mismanagement in California cost taxpayers $31 billion, but her regulatory agenda is the most anti-worker set of policies perhaps in modern American history. Which brings us to today. The rules and regulations passed down over the past year by the Department of Labor's Wage and Hour Division will be extremely harmful to American workers, job creators, and small businesses. In particular, the California-inspired independent contractor rule will deprive freelancers across the country of their livelihoods. In California, we've seen journalists, writers, electricians, countless workers in over 600 professions lose their careers because of AB 5, the very law that President Biden has cited as his model. The law was so damaging that the state legislature exempted 109 categories of workers from it. Effective March 11th, thanks to your and Ms. Su's new rule, millions of independent contractors across America could lose their livelihoods, and tens of millions more will be forced into working arrangements that they do not desire. I will be introducing a resolution of disapproval under the Congressional Review Act to nullify this harmful rule and stop the Department of Labor from this nationwide attack on the American workforce. I am also greatly concerned with the Wage and Hour Division's proposed overtime rule, which will be especially costly for nonprofits and small businesses. The rule will force businesses to cut hours, let go of workers, and divert resources to compliance while costing the economy $19 billion. And those aren't the only two concerning regulations coming out of the Wage and Hour Division. What's more, the president's fiscal year 2024 budget requests includes $341 million for the division. That's a nearly 31% increase to carry out its agenda. Ms. Luman, right now, consumer sentiment resembles about what it did during the Great Recession. Gas prices and grocery prices have shot up during this administration, while real wages have gone down. We need to be encouraging economic growth, supporting workers, and empowering job creators. Yet your division's agenda appears to have precisely the opposite objectives. Therefore, I urge you to withdraw the proposed overtime rule, to stop the final independent contractor rule before it takes effect, and frankly, to rethink any regulation that is negatively impacting American workers, job creators, and small businesses. With that, I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman, and thank you, Ms. Lohman, for testifying before the subcommittee today. The Biden administration and congressional Democrats have prioritized, excuse me, growing our economy from the bottom up and the middle out, resulting in a recovery that has far outpaced expectations. For instance, the American Rescue Plan Act, which passed without the single support of a single congressional Republican, helped vulnerable workers make ends meet and keep them in the workforce. And the Inflation Reduction Act, which also passed without the support of a single House Republican, accelerated our economic growth, lowered costs for workers and families, and helped families keep a roof over their heads and food on their tables. Well, don't take my word for it. Don't take my word for it. Just look at the numbers. I think there should be a slide somewhere. But according to the Bureau of Labor Statistics under President Biden, the economy has added 14.8 million jobs, with 2021 representing the second largest years of job growth on record. 127,800 of those jobs were created in my district within the Charlotte, Concord, Gastonia metropolitan area. And that's more jobs created in his first 2 years in office than former President Trump created in all 4. Furthermore, President Biden has fully embraced a progressive pro-worker regulatory agenda by raising federal contract workers' pay to $15 an hour and repealing harmful restrictions imposed by the previous administration that allowed unscrupulous employers to misclassify workers and evade liability for labor violations. While wages and salaries have grown faster than prices since the beginning of 2021, thanks to the Biden administration and congressional Democrats handling the economy, our federal minimum wage has not kept up with prices. It's simply not feasible for residents to live off of $7.25 per hour. An increase in the federal minimum wage is something that I've fought for since my days in the North Carolina State House, and it is indeed needed as much as ever today. Working hard's not enough if you don't make enough. And lastly, Americans filed over 5.5 million new business applications in 2023, far exceeding the pre-pandemic rate. Bidenomics is not only good for workers, it's good for business. Contrary to my Republican colleagues' claims, President Biden and committee Democrats have always been committed to supporting workers and business owners. The most dangerous proposals for our economy come from hardline Republicans who want to turn back the clock on fundamental workplace protections that date back to the New Deal. Republicans on this committee have spent more time this Congress undermining Acting Secretary Sue than protecting children from being forced to work in slaughterhouses. For example, the Trump administration gave unscrupulous employers a free pass to misclassify workers and deny them essential protections like overtime, minimum wage, workers' compensation, unemployment, and health and safety protections. And the lack of strong workplace protection winds up costing workers, families, and taxpayers billions of dollars. The Trump-era Fair Labor Standards Act, joint employer rule, would have ultimately cost workers more than $1 billion a year. And the Trump-era rule, independent contractor rule, would have cost workers nearly $4 billion each year in lost wages and benefits. Workers should get the money that they earn and have the workplace protections that they deserve. Congress must support, not obstruct, the wage and hour division's progress to deliver for workers and their families. And under Ms. Lohman's leadership, the wage and hour division is expanding overtime pay protections for an additional 3.6 million Americans, returning millions of stolen wages to workers' pockets, and leading an interagency effort to hold unscrupulous employers accountable for endangering children through unsafe and illegal child labor. Unfortunately, years of Republican-led funding cuts have undermined the department's ability to adequately enforce wage and hour laws thoroughly and to thoroughly investigate violations. We can't afford to go backward to a time when young children work long hours in hazardous workplaces, when employers could demand workers stay on the job for 12 hours a day, and when it took to break the law, and when all that it took to break the law was to get off the hook. And so, Mr. Chairman, again, I want to welcome Ms. Lohman, and I thank you again for appearing before us today and look forward to a productive conversation. Thank you, Mr. Chairman. I yield back.
Pursuant to Committee Rule 8C, all committee members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. after 14 days from the date of this hearing, which is February 28, 2024. And without objection, the hearing record will remain open for 14 days after the date of this hearing to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. I note for the subcommittee that some of my colleagues who are not permanent members of this subcommittee may be waving on for the purpose of today's hearing. I will now turn to the introduction of our distinguished witness. Our witness today is the Honorable Jessica Luman, who is the administrator of the Wage and Hour Division at the U.S. Department of Labor, located in Washington, D.C. Ms. Luman was sworn in as administrator on November 29, 2023, following a Senate confirmation vote of 51 to 46. Ms. Luman has led the WHD through the entirety of the Biden administration, where she previously held the position of acting administrator and principal deputy administrator. Prior to her federal service, Ms. Luman was the executive director of the Minnesota State Building and Construction Trades Council and commissioner of the Minnesota Department of Commerce. She holds a JD from the University of Minnesota Law School and a BA from the George Washington University. We thank the witness for being here today and look forward to your testimony. Pursuant to committee rules, I would ask that you limit your oral presentation to a 5-minute summary of your written statement. I would also like to remind the witness to be aware of her responsibility to provide accurate information to the subcommittee. I will now recognize Ms. Luman.
Thank you so much, Chairman Kiley, Ranking Member Adams, and the members of the subcommittee. And thank you for the opportunity to testify today about the important work of the Wage and Hour Division of the U.S. Department of Labor. The mission of the Wage and Hour Division is to promote and achieve compliance with federal labor standards to protect and enhance the welfare of the nation's workforce. I would like to focus this morning on 3 areas of the division's work. First, I would like to review the laws that we administer and the scope of our engagement with employers and workers. Second, I will provide examples of some of the impact of our enforcement and compliance assistance. And lastly, I will briefly touch on our work to combat child labor. As you know, the Wage and Hour Division administers and enforces fundamental workplace protections enacted by Congress, including the Fair Labor Standards Act, the Family Medical Leave Act, the prevailing wage requirements of the Davis-Bacon Act and Service Contract Act, and other federal labor standards laws. Collectively, the laws enforced by the Wage and Hour Division protect more than 165 million workers at 11 million workplaces throughout the United States. These foundational protections are as vital today as they were when they were enacted, because we know that our nation's economy is strongest when workers get paid what they have earned on payday and when businesses can compete on a level playing field. During this last fiscal year, the Wage and Hour Division, we recovered more than $274 million in back wages and damages for more than 163,000 workers. We also made significant progress to combat illegal child labor, conducting 955 investigations that found violations affecting nearly 5,800 children, and we assessed more than $8 million in penalties for these violations. The division conducted more than 4,500 outreach events, providing compliance assistance and information to more than 450,000 stakeholders. And we provided confidential compliance assistance through almost 1 million calls to our 54 district offices across the country. The Wage and Hour Division is fully committed to protecting our country's most vulnerable workers and ensuring that workers receive their hard-earned wages. For example, in a recent investigation in Georgia, we recovered $71,000 in back wages for 16 home care workers who were not paid overtime. And one of these workers told us that the money helped her get caught up on her bills and put food on the table. And we protect employees who are misclassified as independent contractors and who lose the full wage and hour protections that they're entitled to. In Florida, we recovered $28,000 in back wages for 36 restaurant employees, many of whom were dishwashers who had been misclassified as independent contractors. We address retaliation against employees who assert their rights and cooperate in wage and hour investigations. We protect construction workers who are essential to building our nation's infrastructure. We ensure that eligible employees have job-protected leave and that new mothers have protections to pump breast milk at work, including expanded protections provided by the Pump Act. And of course, one of our greatest priorities is protecting children from unlawful child labor. Positive and safe work experiences allow young people to develop skills and earn money and learn what it's like to be part of the workforce. But a job should never jeopardize a child's well-being or education. We investigate every actionable child labor complaint, tip, and referral. And since 2019, the division has seen an 88% increase in the number of children employed in violation of federal child labor laws. And I want to be clear that this increase is a direct result of our focus on this issue and reflects our work in uncovering and investigating more child labor cases. To address the most egregious forms of illegal child labor, last February we launched a national strategic enforcement initiative to combat unlawful child labor, and we're also taking a whole-of-government approach through the Interagency Task Force to combat child labor exploitation. In addition to our enforcement efforts, the division is continuing important rulemakings and guidance and outreach and education to ensure employers understand their responsibilities and that workers understand their rights under the law. At the Department of Labor, we know that the vast majority of employers want to comply with the law, and we are committed to supporting them. We have held over 14,000 events to provide wage and hour information to employers and small business owners, workers, and other stakeholders since the start of this administration. And we are committed to continuing to look for ways to build a strong economy that works for everyone. I want to thank you again for the opportunity to appear before you today, and I look forward to your questions. Thank you very much.
Under Committee Rule 9, we will now question witnesses under the 5-minute rule. I will recognize the gentleman from Missouri, Mr. Burleson, for 5 minutes.
Thank you, Mr. Chairman. Ms. Lohman, the Department of Labor's proposed overtime rule is deeply concerning for the well-being of our nation's small businesses, the nonprofits, universities, and all of the employers, really. The Department of Labor's approach has raised serious issues, particularly regarding the insufficient comment period and the lack of consideration for the challenges faced by businesses. The rush to push through the rule without a reasonable and meaningful comment period is a disservice to both employers and workers because a 60-day window is insufficient. This is particularly concerning because of the fact that much of the information necessary to assess the rule accurately did not exist yet. During the witness testimony on the proposed overtime rule at a hearing held in November before this committee, I was able to ask Mr. Paul DeCamp, who is a wage and hour attorney and the former administrator of the Wage and Hour Division under the Bush administration, if he had ever seen or experienced having such a short comment period for a policy of this magnitude, and his answer was that he had not seen anything like this in his 25 years of experience in wage and hour issues. Ms. Luman, could you tell us why the proposed rule was pushed through so quickly and in such an unprecedented manner?
Thank you, Congressman Burleson, for your question. As you know, the Fair Labor Standards Act includes the protection of workers from overtime. It's been a cornerstone of the law since its enactment. And so enforcing the overtime protections under the Fair Labor Standards Act is absolutely a priority of the Wage and Hour Division. As a matter of fact, about 84% of the back wages that we collect for workers is associated with their failure to receive the overtime that they have earned on payday. We have issued a proposed rule to address a specific exemption from protections from the Fair Labor Standards Act, which is the exemption that applies to executive, administrative, or professional employees. When an employee is exempt under that particular rule, under that particular law, that means that they don't get the protections of minimum wage or overtime. Therefore, it's very important that we're very careful about who is considered exempt for purposes of that requirement. We have proposed a rule, and the proposed rule was issued and will continue to be developed in compliance with the Administrative Procedures Act. We did provide a 60-day comment period in which we received over 33,000 comments from people who were interested in making sure that we developed the best rule that we possibly could.
Imagine if you'd kept that period open to a normal length of time, how many comments you would have received.
Thank you, Congressman Burleson. This rule is following on a rule that was adopted in 2019. It's been about 5 years since we updated the overtime regulation. And similarly, that rule was adopted under the EPA and had a 60-day comment period.
You know, the 2016 rule that occurred under the Obama administration, it faced serious legal challenges and it was ultimately blocked. I expect and hope that the same outcome will happen with this. Our job is to protect the interests of small businesses, the non-for-profits, and the workers across this country, which is done largely by keeping the government from overreaching and causing more problems. That's why we must prioritize policies that foster economic growth, support job creation, and create a system where businesses can be successful. The Biden proposed rule does the opposite, in my opinion, of these things, which is why I have introduced the Overtime Pay Flexibility Act. I'll be introducing that this week. To address these issues and to stop the Biden administration from implementing these new overtime rules. And with that, Mr. Chairman, I would encourage other members to take a look at this new bill that I'll be filing. And with that, I yield back.
I now recognize the ranking member, Dr. Adams, for 5 minutes.
Thank you, Mr. Chairman, and thank you again, Ms. Lomont, for being here, Ms. Loman. The Republican economic agenda in the states appear to hinge on putting children to work and making them work for longer hours. What are the risks to children's educational outcomes when they work more than 20 hours per week during the school year?
Thank you so much, Ranking Member Adams. Addressing child labor and illegal child labor and child labor exploitation is a priority of the administration. And as you know, one of the primary focuses always has been of the Fair Labor Standards Act is to protect our most vulnerable workers, and that includes children.
Thank you, ma'am.
The reason that we really want to focus on making sure that we are protecting children from illegal child labor is because it does have detrimental effects on both their health and educational opportunities.
Great, thank you very much. The Wage and Hour Division assessed a penalty of $1.5 million for Packers Sanitation Services, a major cleaning contractor for meatpacking companies, because it illegally employed more than 100 children across 8 states. The Financial Times described this penalty as trivial. Do you think the child labor penalties that you're able to assess under current law provide an adequate disincentive to employers?
So again, thank you for raising this issue, Ranking Member Adams. Child labor and child labor exploitation, to the extent that we are seeing across the country, particularly as it relates to certain types of work where children should never be in the first place, including cleaning the kill room floors of meatpacking facilities across the country. The penalty that we are able to assess is currently a little over $15,000 per violation. And we recognize, and we've called on and asked for Congress to look at whether or not that is sufficient level of a civil money penalty in order to both, penalize for the type of violations and exploitation that we're seeing, but also, frankly, so that we can deter future violations of child labor laws, because we know most employers are trying to comply with the law, and when children are exploited and children are employed illegally, that really hurts all businesses and all workers. Okay,
so, and I think you've probably answered some of it, but can you explain the new approach that you've taken to assessing penalties on a per violation basis instead of a per child basis, and whether you think that this will help to create a disincentive to violate child labor laws.
Thank you, Congresswoman Adams. And of course, the way that we are assessing civil money penalties is in accordance with the Fair Labor Standards Act, as well as in accordance to the regulations that have been adopted. And the statute says that we should be assessing civil money penalties per violation of the child labor laws. But we also recognize that there are different types of child labor laws. And so we want to make sure that the civil money penalties are assessed appropriately for the most egregious type of child labor exploitation.
Okay. So according to Anna Stansberry's research with the Peterson Institute for International Economics, a typical firm would need to expect a chance of at least 77 to 88% that its violation would be detected in order to have an incentive to comply with the FLSA. So in 1948, the WHD employed roughly 1,000 inspectors, and 22 million employers were covered by laws enforced. So how many inspectors does your agency currently employ, and how many employees are currently covered by laws that your agency enforces? And what would it mean in workers and children's lives if your agency had sufficiently more inspectors?
Thank you, Congresswoman Adams. We currently have 721 investigators to protect 165 million workers at 11 million workplaces across the country. And significantly more workers need our help. We need to be where workers are. We need to be able to be responsive to employers' requests for technical assistance and compliance help. We absolutely need more resources in the Wage and Hour Division to meet the needs of the most vulnerable workers, but also to make sure we have an economy that's working for everyone.
Absolutely. Thank you. I certainly agree. Mr. Chairman, I yield back. Thank you very much for your questions, for your answers.
I now recognize the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
Thank you. We've had testimony before here regarding children who may be working overtime, maybe working late at night. If your department finds children who you suspect may be here from another country, which would indicate maybe shouldn't be here, what do you do about it? What's the follow-up with, say, a 16-year-old child who's working third shift?
Thank you, Congressman Grotham. I appreciate the opportunity to meet with you today. As you know, protecting children from illegal child labor is, in fact, one of our top priorities. And in the Wage and Hour Division, when employers are employing children in violation, our responsibility is to enforce the Fair Labor Standards Act. And so fundamentally, at the end of the day, employers have the responsibility for stopping illegal child labor, and we need to hold employers accountable.
Okay,
when they're violating the law.
if you find a child like that, okay, what do you do with the child?
So again, thank you, Congressman Grotham. We are focused on holding employers accountable and ensuring that they're complying with the law.
Yeah, what do you do with the child? I mean, if we have a child who is a minor and working illegally, do we call their parents? Do we say, do you know your child was working at the L&M manufacturing plant at 2 in the morning? Do you contact the parents?
So again, Congressman Grotham, we're responsible for enforcing the wage and hour laws and the child labor laws. But what we do, because we know that children are particularly vulnerable, and we want to make sure, and it's a responsibility of everyone across the community to make sure that we're protecting kids. We work very closely with community-based organizations. We work very closely with other types of agencies that provide services to make sure that kids have access to those services.
Do you make an effort to find that person's parents, to find out whether they're even living with their parents?
So again,
you don't consider that your responsibility. You just say, well, okay, we found little Johnny at 2 in the morning in the factory. We'll call some other agency, and we'll maybe send a nasty letter to the employer, and we just don't care if that 15-year-old even has a parent in the country. Is that your attitude?
So, Congressman Grotham, I care very, very much, and I care very deeply about every child who's employed illegally in this country. And we, of course, work very closely with everyone who can provide services and meet the needs of those kids. But we also are holding employers accountable for employing children illegally in the first place.
Okay. There was an article in the New York Times. The Biden administration insisted it was a high number. So let's say there's somewhere between 35,000 and 85,000 unaccompanied minors in this country. By that I mean their parents aren't even here. And obviously some people they're living with somebody, somebody's making money off them. Does that concern you? I mean, I would think if I found somebody, maybe if they could barely speak English, working clearly illegally, even if they were, by all accounts, an American child, I would call their parents and say, what's going on? Why is Johnny at such and such a place at 2 in the morning? Now, particularly in light of the fact that, according to the New York Times, tens of thousands of these minors have been lost. We don't even know where they are. Don't you think the bureaucracy has some duty to find out who's taking care of these kids or if their parents are anywhere to be seen?
Thank you, Congressman. You know, we recognize that many times there are children who are particularly vulnerable to child labor exploitation, and this could include, and recognize that this could include immigrant workers and
You make
immigrant
no
children.
effort to contact their parents. I guess that's the final question.
And Congressman, I just want to say that our responsibility is to both keep these kids safe and also to make sure that employers stop employing children illegally in this country.
Okay, well, if you aren't contacting their parents, I don't see how you're making an effort to keep them safe. But we'll switch to another topic. Independent contractors. We all know, or at least should know, people are independent contractors and love it. Uber drivers are an example of people who love their job and brag about how much money they're making and blah, 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 blah. Your independent contractor rule, truckers would be another one, would prevent these American citizens, who used to mean you were free to do kind of what you want, they love this independent contractor arrangement where they have a lot of freedoms as to how and when they're going to work, make a lot of money. Does it bother you? You're taking the freedom to enter into these contracts, which the Uber drivers enter into. Does it bother you taking away from them, who should know what's best, for themselves, the ability to work as an independent contractor?
Thank you, Congressman. We are focused on addressing misclassification of workers who should get the protections of the Fair Labor Standards Act, but we very much recognize that independent contractors are running their own businesses or in business for themselves and are really an important part of the economy.
Insurance agent, does that bother you? If a smart PhD insurance agent, you take away his or her ability to operate as an independent contractor?
So, Congressman, again, in the Wage and Hour Division, we're focused on addressing misclassification of workers who have been misclassified as independent contractors. But we very much, and our new rule very much protects both employees under the Fair Labor Standards Act and independent contractors who are not covered by the Fair Labor Standards Act and are in business for themselves.
The gentleman's time has expired. I will now recognize the gentlewoman from Michigan, Ms. Stevens, for 5 minutes.
Thank you, Mr. Chair, and so great to see you, Administrator Lumen. I'd say since your appointment, you are the right person at the right time for a very critical agency. And we're thrilled to see that you've recouped those $274 million just in fiscal year 2023 alone, the you being the collective view of the Wage and Hour Division. And this is impacting 163,000 workers across the country. You're recovering more than $17 million in back wages for workers on federally funded projects alone whose employers just didn't abide by prevailing wage laws. And I just wanted to kind of talk about the process a little bit and how these investigations work and how your team identifies these stolen dollars that are owed, and then how they end up getting recouped, because that's got to be very complicated. And I assume you're not in the business of just straight up gotcha, but we need people to advocate for workers. It is not up to those of us on this committee to say, you must enjoy being an independent contractor who doesn't get your full wage, right? We know we've got issues with looming retirement gaps, Social Security challenges here in this country, and that, yes, we've got record employment in this country, and yet we see that the American people, and this is so pertinent to us in Michigan and throughout the industrial Midwest, which is this effort of a good job, right? And so the role in which your agency helps individuals maintain the dignity of work and maintain the opportunity to earn what is owed to them and achieve that tenet of a good job. I just want to kind of understand the process here and what your investigators go through.
Thank you so much, Congressman Stevens. Really appreciate the question. And again, really value the work that we're doing at the Wage and Hour Division. Every single investigator who wakes up every day to really help workers and help employers and ensure compliance with the law. The Wage and Hour Division, as you say, we are very much focused on making sure that jobs are good jobs and that workers get their hard-earned pay on payday. And so we do that. A lot of the work that we do is really about preventing wage and hour violations from happening in the first place. Yeah. Prevention is so important because we know employers really want to get this right. We know they want to comply with the law. We also provide a lot of compliance assistance so that employers can understand what their obligations are and workers can understand what their rights are, but really so that we can help employers get everything right before there's a problem. And then we do our enforcement work, and as you've seen, a lot of our enforcement work results in recovery of back wages for workers who should have gotten that pay on payday. So we're very much focused on making sure that we have good jobs. When we conduct an investigation, and we do that whether it's based on a complaint or an agency-initiated effort or a referral or a tip, when we initiate an investigation, we are absolutely meeting with the employer, explaining to them what we're investigating, the information that we're going to need. We keep the employer informed all the way along the investigation. We talk to workers. We find out what's happening. We need to learn and understand what violations may be occurring. And then, of course, when we assess the back wages and penalties, we're also ensuring that we are achieving compliance going forward.
Yeah, and I wanted to give you a minute to explain that. And I really think that is a beautiful thing that this committee needs to absorb and understand that's going on in your agency, because it's hand-holding, it is working together. Imagine if you're that worker. You know, who do you turn to? Who do you know to go to? I mean, I'm sitting here, I'm a member of Congress, and I need to be supporting your agency, your department, and alongside, by the way, this acting administrator, Julie Sue, who needs to get confirmed. You know, we need to function. We need to continue to grow our economy. We need to continue to build off of the successes that Biden's put in place. But I want to make sure my constituents know about this. And not because it's a gotcha, but because it's a vulnerability, right? And it is about getting what is owed to you, and it is about rising costs and putting food on the table and making sure your kid can do all the sports programs, and God forbid there's a medical issue. So let's keep digging on this. This is an important hearing, and thank you so much, Administrator Lumen, for your time. I'll yield back, Mr. Chair.
I now recognize the gentlewoman from Illinois, Ms. Miller, for 5 minutes.
Thank you, Chairman. Joe Biden's own Department of Health and Human Services and Department of Homeland Security have acknowledged the increase in child trafficking under the Biden administration. Even the liberal New York Times is reporting on the child trafficking crisis that the Biden administration has created by opening our southern border. You can see on this chart the massive spike in child trafficking during the Biden administration because Joe Biden is allowing cartels to traffic children across our border. Administrator Lumen, do you think the open border policies of the Biden administration have caused the increase in child labor violations?
Thank you, Congresswoman Miller. Pleasure to be here with you today. So the Biden administration is very much focused on ensuring that children are not employed illegally in this country. And we've launched several different efforts.
The Biden administration has lost 85,000 children. And actually, I was recently at the border, and the Border Patrol suggested that it was over 100,000. They have lost 85,000 children during this disaster at the border. The spike is during your administration. You own this. It is because of the border policies. Has President Biden taken any responsibility for the uptick in child exploitation?
Thank you, Congressman Miller. Absolutely. We're doing several things across the administration, including we have an interagency task force to address and combat child labor exploitation. We're working very closely with the Department of Labor, the Department of Homeland Security, the Department of Health and Human Services to make sure that we are addressing, combating, and preventing child labor exploitation from occurring all across the government. We're also working with states and other partners across the country to address this really important issue.
Well, you're failing at it because you can't even find the children. 85,000 minor children are missing. It's a disaster. DHS is reporting that the 85,000 children who cross the border are missing. Does the Department of Labor have any idea where these 85,000 children are? I've heard that the Biden administration is paying people that are here illegally, adults that are not related to these children, to care for these children. Do you know where, does the Biden administration have any idea where 85,000 children have gone?
So, Congressman Miller, again, we are working across the entire administration to address and prevent child labor exploitation, and this is absolutely an area of focus for all of us.
So you don't know where these 85,000 children are? This is what the Biden administration does. They create horrible crises, then they demand Congress give them money to fix the crisis, then they use that money to make the crisis worse so they can ask for more money. You are allowing cartels to traffic children into our country and doing nothing to stop them, and I wouldn't give you a penny. Chairman, I yield back.
Administrator Lumen, my colleague across the aisle here, Ms. Stevens, said that Acting Secretary Julie Su needs to get confirmed. Do you agree with that?
Thank you, Chairman Kiley. I am honored and privileged to get to work with Acting Secretary Su. Under her leadership, we are doing really important work at the Wage and Hour Division in the U.S. Department of Labor.
Okay, but the question I asked, can you answer that?
Chairman Kiley, I certainly defer to the U.S. Senate as to the confirmation process. But again, it's an honor and a privilege to get to work with Acting Secretary Su.
But we have, bipartisan, statements here, maybe meant a somewhat different way from myself and Ms. Stevens, that Acting Secretary Su needs to get confirmed if she's going to stay on as the head of the Labor Department. Do you agree with that?
Chairman Kiley, and I very much admire and appreciate and get to the opportunity to get to work with Acting Secretary Su.
Right, but do you think she needs to get confirmed?
Chairman Kiley, I certainly defer to the U.S. Senate, but under the Biden administration, we are very much focused on protecting workers and making sure that the U.S. Department of Labor is functioning in a way that absolutely is helping employers be successful.
Do you think having an unconfirmed secretary has affected morale at the Department of Labor?
So, Chairman Kiley, again, the team that I get to work with and everyone that I get to work with at the U.S. Department of Labor is very much focused on protecting workers in this country and making sure we have an economy that works for everyone.
Thank you for that, but I asked a different question. I said, do you think that having an unconfirmed acting secretary who set all the records for how long she's been there without being confirmed, do you think that has affected morale at the Department of Labor?
Chairman Kiley, I think morale at the U.S. Department of Labor is exceptional.
I now recognize the gentlewoman from Minnesota, Ms. Omar.
Thank you so much for joining us today, Administrator. Your agency has been fighting the child labor crisis before it became a major news story. The Wage and Hour Division's enforcement actions have impacted almost 6,000 children, marking an 80% increase since 2019. This is an issue that both Democrats and Republicans should prioritize, especially in this subcommittee, and yet we have not held a hearing. We have not seriously discussed or marked up a useful legislation either. Although Congress's legislative and funding focus on child labor has been lacking, to say the least, I'm relieved that this administration is doing whatever it can to mitigate child labor violations. Administrator Lumen, could you describe how your office has enhanced its enforcement work, even with limited resources? And can you outline actions taken by DOL Task Force on Child Labor Exploitation that launched last year?
Thank you, Congressman Omar from the state of Minnesota. Absolutely. child labor exploitation has and continues to be one of the primary focuses of the Wage and Hour Division and the U.S. Department of Labor. We have to protect the most vulnerable workers in America, and those include children. So the work that we're doing, which is very resource intensive when we're looking at Packer Sanitation Services, Inc., for example, where we found more than 102 children who were working in violation of the child labor laws, and that was across 13 states. 13 facilities in 8 states, but there were kids as young as 13. And so this has just got to be a priority, a focus, an area where we are absolutely putting the full expertise and be laser focused across the Wage and Hour Division to protect these kids. So we very much are launched this National Strategic Enforcement Initiative to address child labor exploitation. And this is something that we are making sure that all of our investigators are equipped with the resources and the tools that they need to be able to identify the red flags of child labor violations and then also to enforce those violations. We also have the Interagency Task Force, which is the whole of government approach, where all the departments across the administration are recognizing that they have a role to play in helping make sure that we are combating child labor exploitation and keeping kids safe.
You've had some successes recently. Can you give us an example of some of those successes?
Yes, absolutely. Thank you, Congresswoman. So again, just recently, we had a case out of Minnesota where we were finding that there were teens that were employed illegal to operate dangerous equipment at a foods manufacturing facility. We have some cases across California where we found that children were being responsible for the meat packing facilities and actually working on the kill room floor, killing poultry. And that was a $3.8 million recovery of civil money penalties as well as violations, as well as other FLSA violations. And then we've also found children working in automobile, that's the word I'm looking for, an automobile manufacturing where we find those children working in violation as well.
Thank you for those examples. I know that, we were also having conversations about addressing misclassifications. Ms. Lumen, could you walk us through the process of a typical investigation into misclassification?
Thank you, Congresswoman. Again, misclassification of workers of employees as independent contractors is a priority of the Wage and Hour Division and of the department, and we're specifically focused on the most low-wage vulnerable workers who may be deprived of their opportunity to get minimum wage and overtime. And so we're very much looking for and seeing, unfortunately, workers like healthcare workers or construction workers, or, as I said, dishwashers who have been misclassified as independent contractors and therefore deprived of their opportunity to get overtime wages. That's what we're particularly focused on and concerned about, and that's where we're making sure that we're protecting all vulnerable workers and making sure they get their rights under the law.
Yeah, really appreciate that work. Wage theft cases have been rising in Minnesota, and our State Attorney General Keith Ellison has been working really hard to make sure we address some of the problems that exist in the gig economy. And I appreciate you and him and all of the people that are working on this issue. Thank you so much, and I yield back.
Chairwoman Fox is recognized for 5 minutes.
Thank you, Mr. Chairman. Administrator Lumen, in November, a witness testified before the subcommittee that automatic updates to the Fair Labor Standards Act's exempt employee salary threshold would violate the notice and comment rulemaking requirements of the Administrative Procedure Act and potentially the Constitution. The proposed overtime rule includes these automatic updates. What will you do to address these concerns?
Thank you, Congresswoman Fox. As we've discussed, one of the most important and foundational issues of the Fair Labor Standards Act is overtime protections for ensuring that workers get time and 1/2 of their regular rate of pay after 40 hours in a work week.
And we know that.
Okay. And the exemption for some workers to not get those protections is something that we're focused on in making sure that when we're adopting an appropriate level of salary threshold for that exemption, when workers don't get that protection, that's what we're working on and looking at an overtime rule.
I want you to address my specific question. We know what the situation is. Don't waste our time on that. Specific question. What are you going to do because you're in violation of the Administrative Procedures Act and the Constitution?
Thank you, Congresswoman Fox. We absolutely will adopt and ensure that where the adoption of the overtime regulation is in accordance with the Administrative Procedures Act, and automatically updating this salary level does comply with the APA and the Fair Labor Standards Act.
We'll see. Administrator Lumen, this committee's received testimony which has been well documented in studies that Davis-Bacon Act requirements disproportionately harm the ability of small businesses to compete for federal construction projects. This is especially concerning because more than 82% of construction industry workers are employed by a small business. Regrettably, Democrats in Congress have attached prevailing wage requirements to new infrastructure and energy projects, and the Biden Wage and Hour Division has expanded the scope of Davis-Bacon through its recent final rule. With these recent developments, are President Biden and the congressional Democrats telling small businesses they need not apply on federal construction projects?
Congresswoman Fox, again, as we've discussed, the Biden administration is very much focused on ensuring that federal investments result in good jobs. And the Davis-Bacon Act, as you know, currently applies to more than 71 different types of investment vehicles that have been passed by the Congress. And we at the Wage and Hour Division are focused on ensuring that when the Davis-Bacon requirements apply to the federal investment, that those are in fact good jobs that are being paid the appropriate prevailing wage as required by law.
Okay. You're spending taxpayer dollars, not making a federal investment. Let's make that clear. Last year, I questioned Acting Secretary Sue about the Wage and Hours Division's historically abysmal record for its enforcement. The numbers are now in for fiscal year 2023, and WHD has again reached new lows. Specifically, the WHD had the fewest number of compliance actions and the smallest amount of back pages collected in a decade. This was almost 40% fewer compliance actions and 15% fewer back wages collected. WHD's budget is more than 20% higher than it was in FY 2013, demonstrating this is not a resource problem for you. It is a management problem. What management changes will you commit to making to improve these outcomes?
Thank you, Congresswoman Fox. Again, as we discussed, we have about 721 investigators to protect 165 million workers at 11 million workplaces across the country. And so we're very much focused on ensuring that we are protecting the most vulnerable workers. And that requires that we are particularly strategic with the utilization of our resources. We talked a lot about child labor and child labor exploitation, and we are making sure that we are putting and focusing our resources in that area. But we also are continuing to
But you had
protect-
more money and you did less work. That doesn't make any sense. What is the problem?
Thank you, Congresswoman Fox. As you know, the agency has been primarily flat funded for the last decade, and that has resulted in, as expenses and costs go up, that we have fewer resources to actually provide for the enforcement work that needs to happen, which is why we have, the President has asked for increased funding for the Wage and Hour Division.
Mr. Chairman, I yield my time to you.
Mr. Lumen, you said you are going to defer to the U.S. Senate on the confirmation of Acting Secretary Sue, but are you aware that the U.S. Senate returned her nomination to the President without confirming last year?
Congressman Kiley, yes, I am aware of that.
So wouldn't deferring to the U.S. Senate mean putting in someone who they're willing to confirm?
So, Congressman Kiley, the President has renominated Acting Secretary Sue for that position, and I recognize that that is often the case, that nominees are renominated at the expiration of their preliminary nomination.
The gentleman from Michigan, Mr. Wahlberg, is recognized for 5 minutes.
Thank you, Mr. Chairman, for allowing me to wave on here, and I appreciate the witness being. Following up on questions of some of my colleagues, Administrator Lumen, as you are aware and indicated in 2023, the New York Times reported on many children being trafficked and forced to work illegally in the United States, which is tragic. Last year, you briefed committee staff on Wage and Hour Division's efforts to collaborate with other agencies via the the President's Anti-Trafficking Interagency Task Force. You noted that the first meeting of that task force was on May 23rd of last year. Was that the only meeting that the task force held?
Thank you, Congressman Wahlberg, and it was great to be able to brief the staff on the work that we're doing in the child labor to prevent and address child labor exploitation. So the Interagency Task Force to combat child labor exploitation, which is led by the Department of Labor.
Was that the only meeting that you had?
Thank you, Congressman. That we have met several times with cross-agency leadership, as well as addressing issues and working along in the interim to make sure that every agency that's participating in addressing this really critical, important issue.
Are these meetings held regularly?
So, Congressman Wahlberg, we continue to convene and we come together to discuss these really important issues. We have done that so several times.
Would you commit to having a follow-up briefing with committee staff on the work of Wage and Hour and the task force on this issue?
Congressman Wahlberg, absolutely, would be happy to do that.
Great, because those meetings haven't been highlighted too much, and that's the reason for the question. As you may know, I'm the lead sponsor of H.R. 5419, the Direct Seller and Real Estate Harmonization Act, which is a bipartisan bill. It would incorporate language from the Internal Revenue Code into the Fair Labor Standards Act to harmonize the statutes and ensure that individuals who choose to work in direct selling or real estate are classified as independent contractors under both laws. Unfortunately, the Wage and Hour Division declined to accept stakeholder recommendations to incorporate this fix in the final independent contractor rule, which is disappointing. Additionally, the Small Entity Compliance Guide and Frequently Asked Questions, released in conjunction with the final rule, creates more confusion. And so, Ms. Luman, do you commit to working with me to ensure additional guidance is provided so legacy independent contractors have clarity under both statutes?
Thank you, Congressman Wahlberg. We absolutely want to provide the information guidance that is needed so that everyone can comply with the law. So absolutely committed to making sure we're continuing to develop resources, information, but also doing outreach, assistance, education, and specific compliance help for anyone who needs help to make sure that they understand how to comply with the Fair Labor Standards Act.
So I can count on that then? Okay, thank you. In September 2023, the DOL published a new proposed overtime rule, which would raise the salary threshold on additional 55% from the most recent adjustment made during President Trump's administration just 4 years ago. As you're aware, in 2016, the Obama administration's overtime rule was blocked by a federal judge because DOL's interpretation of the Fair Labor Standards Act overtime provision was found to be arbitrary and capricious. Could you discuss the legal challenges the new rule may face?
Thank you, Congressman Wahlberg. As we've discussed, overtime is a primary focus of the Fair Labor Standards Act in protecting workers who should be receiving overtime is the work that we do at the Wage and Hour Division. The proposed rule is still in development. As we said, we've received about 33,000 comments on this rule, and we are continuing to evaluate those comments and to make sure we can publish a final rule. So I can't speculate as to what potential litigation might be, but we are very much focused on protecting workers and ensuring that they get their hard-earned wages on payday.
But I would assume that we have learned from the action by the judge on Obama's rule, so we won't be going that direction again, will we?
So, Congressman Wahlberg, again, we are very much focused on reviewing all of the comments that we received and finalizing a rule, an overtime rule that will continue to protect workers who should be protected by the Fair Labor Standards Act.
Okay. Thank you. My time has expired. I yield back.
The gentleman from Virginia, Mr. Scott, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Administrator Lohman, for being with us today. We've heard a lot about misclassification. It usually is talking about independent contractors, But in compliance with the Davis-Bacon Act, a lot of people are misidentified in their job. Is that something that Wage and Hour gets into?
So thank you, Congressman Scott. We are both responsible for ensuring that all workers are covered, that are covered by the Fair Labor Standards Act receive their hard-earned minimum wages and overtime. We are also responsible for enforcing the worker protections under the Davis-Bacon Act, which requires that workers who are performing work on federally funded construction projects receive the prevailing wages for the type of work that they're performing.
And what happens when someone is misdesignated as a lower classified worker when actually they're doing higher quality work?
So thank you, Congressman Scott. Sometimes there's sort of two different types of misclassification. So we talk a lot about, and we've been talking a lot today about misclassification of employees as independent contractors, but you're absolutely right. Sometimes when we're looking at federally funded construction projects, because we establish prevailing wages for different types of workers under the law, sometimes a worker may be paid the wrong prevailing wage under Davis-Bacon because they're not classified appropriately for the type of work that they're performing. And we very much work with the contractors, the contracting agencies, as well as workers to make sure that they're getting the correct prevailing wage.
Flight attendants have raised the question of when the work begins. Apparently, a flight attendant doesn't start on the clock until the door closes, when in fact they were doing work-related activities before then. Question has come up, when you show up at the job and suit up, do you start getting paid then, or do you start getting paid when you get to your job site, cleaning up and those kinds of things? How do you know, in the question of flight attendants not getting paid until the door closes, how do you know when this clock starts for the purpose of minimum wage and overtime?
Thank you, Congressman Scott. One of the fundamental issues that we address in every investigation in the Wage and Hour Division, but also in our compliance assistance and our outreach and education, is making sure that workers and employers understand when they're required to pay minimum wages and when overtime occurs. And so we very much are focused on making sure that everyone understands that that off-the-clock work, as you are very familiar with, is not permissible under the Fair Labor Standards Act, that workers need to be paid for all hours that they're working, and that workers need to make sure that they're paid correctly on payday. So we are very much focused in the Wage and Hour Division of addressing when work starts, when work ends, what work is compensable, and we provide an enormous amount of guidance for employers and work very closely with employers, but also want to make sure workers know that they should be getting paid when they're working.
It's the question of flight attendants, is that before your office now?
Congressman Scott, we don't currently have, as far as I'm aware, I'm not aware of any specific issues related to the flight attendants and pay at this time.
You indicated that you've been essentially flat funded for a decade. The Biden administration fiscal year 24 budget would reverse the trend and allow you to hire almost 400 new staffers. What difference would that make in allowing you to fulfill your mission?
Thank you, Congressman Scott. That very much would make an enormous difference in our ability to be able to help more workers, help more employers, prevent more wage theft, make sure that we are preventing more misclassification of workers as independent contractors. The foundational work that we do in the Wage and Hour Division, which is make sure that workers get at least $7.25 an hour and at least time and a half after 40 hours in a work week. All of that work is so important and would only be helped, supported, and expanded by our ability to have more resources.
Thank you. Many states have eliminated the 14C program that allows lower payments for those with disabilities. Can you discuss how the Wage and Hour is working to protect the rights of workers with disabilities under the 14C program?
Thank you, Congressman Scott. Yes, it's our responsibility to enforce the worker protections under the 14C program. It's also our responsibility to issue certificates to employers who are seeking to pay lower than the $7.25, less than minimum wage rate to workers with disabilities. We currently have certificates issued to about 850 employers who are paying or approved to pay sub-minimum wages. This is a dramatic decrease over time. And so our responsibility is to make sure that when workers are working under a 14C certificate, that they are getting exactly what they are supposed to be getting and are protected. It's also our responsibility to hold employers accountable when they're not following the requirements of the 14C program.
Thank you, Mr. Chairman. I yield back.
Starting my 5 minutes now, I'd like to talk with you about the newly announced independent contractor rule, Administrator Lumen. By the way, how many pages is that rule?
Congressman Kiley, I am not sure.
I think it's like about 330. Does that sound about right?
Congressman Kiley, that's very possible.
Okay, so under this new independent contractor rule, would licensed real estate agents, would they be classified as employees or independent contractors?
So Congressman Kiley, as you know, the independent contractor rule lays out a multi-factor, six-factor test.
Sure, and my time's limited, so I'm asking you about a specific example. Just take your typical real estate agent, classic arrangement with a brokerage. Are they an employee or an independent contractor here?
So Congressman Kiley, the independent contractor rule helps provide guidance under the Fair Labor Standards Act, which requires that employees get minimum wage and overtime, and that
okay, you're giving me
independent contractors
generalities,
don't.
and you're avoiding my specific question. Under the rule that you just announced, 330 pages for the 2 million real estate agents in America, is there an answer in there as to whether they're employees or independent contractors?
So, Congressman Kiley, as has always been the case under the Fair Labor Standards Act, it is a fact-based analysis as it relates to that individual worker and how they're performing work for their employer.
Okay, I'm just talking about the classic arrangement of a real estate agent who's sponsored by a brokerage. Would that classic arrangement, take for example, everyone who's exempted by AB 5 in California, would those folks qualify as independent contractors or as employees under the rule that you just announced?
So, Congressman Kiley, again, the rule that we just announced is a reflection of longstanding guidance as well as judicial precedent of what it means to be
Well, good.
an
Then it should be
employee or
easy to
independent
answer. Can you
contractor.
tell me whether real estate agents are employees or independent contractors under your new rule?
So, Congressman Kiley, real estate agents who are in business for themselves would continue to be considered independent contractors under the new rule.
Okay. How about truckers, independent owner operators? Are they independent contractors or employees under the new rule?
So again, Congressman Kiley, the requirement is that workers who are in business for themselves are independent contractors under the Fair Labor Standards Act, and workers who are economically dependent on their employer are employees.
I see.
And
So
get
let me
the
give you an
protections of the
example.
law.
Let's say that I'm a writer and I publish for Vox and I publish for the San Francisco Chronicle and I publish for a variety of local papers. Am I an employee or an independent contractor under your rule?
So again, Congressman Kiley, it would depend on the facts of that individual
I just gave you
relationship,
the
and
facts.
it's a six-factor analysis. It has always been a six-factor analysis as it relates to the judicial precedent and the long-standing guidance of the Department
Okay, so
of Labor.
you're the person who came up with the rule. It's 330 pages, and you can't tell me here some basic examples of standard professions that millions of people have, how they qualify. How is anyone supposed to make heads or tails out of this?
So Congressman Kiley, again, thank you for the question, because what we did in the regulation as well as in the small business guide is that we provided examples of how each of the six factors could apply and indicate an independent contractor or an employee for purposes of helping
Okay, so
with the
could you
analysis
apply
under
those
the Fair Labor
examples to
Standards
the
Act.
hypothetical I just gave you? Is that an employee or an independent contractor for a writer like that?
So again, sorry, Congressman Kiley, it would depend on the analysis of the six factors to that individual worker and the work that they're performing.
I see, and who's doing that analysis?
Congressman Kiley, the guidance that we put out in the regulation is to help employers do that analysis. And then we also, as we've discussed earlier today, we're very much looking for misclassification in our cases when it may have deprived a worker of receiving minimum wages or
In fact,
overtime.
yes, you gave us some examples of the work that your agency has done to address misclassification and the recoveries you've gotten to address misclassification. To be clear, you're doing that under the rule of the prior administration. Is that correct?
So, Congressman Kiley, again, we are doing this under the longstanding guidance as well as the information in compliance with
But no. My
all
question is,
regulations.
you were touting your success in going after unscrupulous employers who are misclassifying workers. You're doing that without this new rule that you just announced, correct?
Congressman Kiley, we are very much focused on addressing misclassification, and
Could
we
you
are
just
doing
answer my
that
question?
under the standards.
You've
that
been
we are
able to
currently-
get judgments and recoveries for misclassification without this new rule, correct?
So Congressman Kiley, we continue to look at misclassification, and this rule is to continue
The answer
to
is
help-
yes. So the reason you're stating for having this rule apparently is not needed. The rule isn't needed because you're already able to pursue these cases. Are you aware of the opposition that the freelance community has to this rule in the form of a lawsuit and many comments to the rulemaking process?
Congressman Kiley, I am aware of that.
And so why do you think it is that they oppose this rule so much?
So Congressman Kiley, again, I think that one of our responsibilities is to continue to do outreach and education to make sure that freelancers who are in business for themselves understand they are protected by this rule.
Yes, and so my time is expired, so I just want to leave you with that question and give you one more chance. Based on your conversations with all these folks who say that this is going to threaten our livelihood, they've submitted comments, they've filed a lawsuit. Why do you think they are opposed to this rule that you just announced? What's your best understanding of that?
So Congressman Kiley, I very much look forward to the opportunity to continue to talk with freelancers and other small business owners to make sure that they understand that this rule protects them in their ability to be in business for themselves.
The gentleman from Virginia, Mr. Good, is recognized.
Thank you, Chairman Kiley, for allowing me to participate in the hearing today. Thank you, Ms. Lumen, for being here. Ms. Lumen, are you concerned about the national debt?
Congressman Good, thank you.
You don't have to say my name each time, by the way.
Oh,
That's
okay.
a stall tactic. But are you concerned about the national debt?
So Congressman Good,
You don't have to say my name each time.
Oh, sorry.
Are you concerned about the national debt?
I appreciate the question. My responsibility at the Wage and Hour
You
Division
work in the
is to
federal
enforce the Fair
government,
Labor
you have a
Standards
budget.
Act.
Are you concerned about the national debt?
So Congressman Kiley, I'm concerned about
I'm not
making-
Congressman Kiley, but-
I'm sorry, Congress.
You don't have to
I
say
won't
my
say your
name. It's okay.
Sorry, I am very much.
Do you know how much the national debt is?
I don't know off the top of my head what the national debt is, sir.
Okay, it's $34 trillion. I'm not surprised because you asked for a 31% budget increase. Could you imagine if every agency and department of the federal government asked for a 31% budget increase? According to the Congressional Budget Office, repealing Davis-Bacon would save taxpayers $24 billion over 10 years. If we would repeal Davis-Bacon, which is what we should do, it would save taxpayers about $24 billion over 10 years. Can you tell the American people why we should pay $24 billion more than is necessary for construction projects, federal construction projects? Why should the taxpayer have to pay $24 billion more for federal construction projects?
So our responsibility at the Wage and Hour Division is to enforce the Davis-Bacon Act as enacted by Congress and the 71 Davis-Bacon related acts. And we make sure that workers get the worker protections under that law, including getting paid prevailing wages for the work that they're performing.
Ms. Lumen, most Americans have never heard of Davis-Bacon. As you know, it's almost 100 years old, having been created in the 1930s as a conglomeration of the many Jim Crow-era laws. It was intended to inflate wages of government contractors and eliminate competition in favor of white union workers, in favor of labor. My bill, H.R. 720, would actually repeal this discriminatory and inflationary policy that is the Davis-Bacon Act. But back in August, your department issued a final rule that not only didn't eliminate Davis-Bacon, as we should, but it updated it. Why would the administration prop up a law with such a racist history?
So our focus in the administration is to really make sure that federal investments result in good jobs. And the Davis-Bacon is one part of ensuring that workers who are performing work on federally funded construction projects get paid locally prevailing wages.
Well, in addition to the history, the racist history of the law, it's actually discriminatory today in a different way, because it discriminates against the 89% of the construction workforce that have freely chosen. I know the administration doesn't like that when workers choose not to join a union, but 89% of construction workers have freely chosen not to be represented by a union. Do you have any concern at all that Davis-Bacon discriminates against those 89% of the workforce that are construction workers?
The regulations that we enforce and the Davis-Bacon Act that we enforce really sets a level playing field for construction contractors who are bidding on federal projects, and then also sets a level playing field to ensure that all workers are being paid not less than the prevailing wages in their local communities.
Yeah, but it discriminates again against those who are not construction or union represented construction workers. Another criticism of Davis-Bacon is that it uses flawed wage data to determine the prevailing wage, the metric set by the Department of Labor. It's been criticized by the Office of Inspector General. The GAO have criticized how the prevailing wage is calculated. The Heritage Foundation did a study that found that 30,000 more construction jobs could be created on an annual basis if the Department of Labor actually accurately calculated Davis-Bacon rates to find the true prevailing wage. However, the new Davis-Bacon rule doesn't do anything to improve the wage survey. And I understand that your goal is probably to artificially increase wages in favor of unions. This doesn't always work. In my district of Charlottesville, the Bureau of Labor Statistics showed, in Charlottesville City in my district, shows that the market wages for cement masons are $22 an hour, but the prevailing wage is $15 an hour, so that's a 30% difference there. How can you justify government intervention that actually deflates workers' wages?
So, as you know, the way that we establish prevailing wages in the wage and hour division under the Davis-Bacon and Davis-Bacon related acts is that we conduct a survey of locally paid wages. And so those surveys are of actual wages paid to actual workers performing construction work by county. And that is very much a way that we are able to establish what the appropriate prevailing wage is. To your point, sometimes the prevailing wage surveys get outdated, which is one of the reasons why we adopted this new rule.
Just a few seconds left, if I may, I'm sorry, but what we should do is repeal Davis-Bacon and let the market determine the wages, but if not, we ought to at least commit to improving this broken wage survey process that takes all the workers into account, including those not represented by a union. And I yield back, Chairman Kiley. Thank you again.
The gentlewoman from Michigan, Ms. McLean, is recognized for 5 minutes.
Thank you. And thank you, Mr. Chairman, for the opportunity to wave on to this subcommittee for this very important hearing. Administrator Lumen, I want to focus on the Department of Labor's new independent contractor rule. But before I get there, I have a couple questions because I want to set the bar right. You are in charge of the wage and hour division, correct?
Correct.
Wonderful. Good. We're off to a good start. Have you ever been a business owner?
Congresswoman McLean,
It's super simple.
I've had the opportunity to run organizations and lead,
All right.
hire,
Let me
fire,
just start, 'cause
manage budgets, all of those
This
things.
will go a lot faster, right? It's really not a trick question. Have you ever been a business owner?
Congresswoman McLean, I have never owned a business, but
Thank
I
you
have
very much.
absolutely managed businesses.
See how simple that is? I ask a question. You don't need to ruffle around. You just give me an answer to the question I have. It's really simple, right? And things will go a lot faster. Because as the person in charge, don't you think you should have some answers? Because if you don't have any answers, who should? Right? You're the boss. And I love it when we have all these people come in to testify. They're in charge. I mean, they write a 300-page rule, but yet when we ask them a simple question, they can't answer it. That's pretty disturbing to me. Like, if you're in charge, you're in charge. I don't think it's too much to ask that the person in charge be able to answer a simple question. So if we could just have some simple ground rules, and I'm even all right with an I don't know, right? I don't expect you to know everything, but I do expect you to know something, right? So let's start with this. You're not a business owner, yet you're making laws for business owners. How many business owners did you consult before making this law?
So, Congressman McLean, we absolutely, specifically, as you're talking about the independent contractor or employee classification under the Fair Labor Standards Act, just to make sure we're talking about the same thing. We held listening sessions specifically for business owners and for
10, 20, 100, 1,000, 1,500. Give me a gut feel.
I believe we held about 27, 30 listening sessions. I don't want to tell you wrong.
That's okay. No, I'm looking for directional answers. It's honestly not a gotcha question. Because what I think the American taxpayer is frustrated with, the American people are frustrated with, and the business owners is we all are making laws for business owners, yet we don't listen to them. We don't take their opinion into consideration. And we make laws and we don't have any idea of the unintended consequences of what those laws will do to the actually people who have to administer those laws. So about 30 listening sessions. And what did the actual business owners have to say?
So, Congressman McLean, again, and I participated personally in a lot of these, so I do want to answer this question very clearly, although we had lots of team members
Let's
who
get to
were on
the
these.
answer.
So we heard a lot of feedback from business owners that they specifically wanted to make sure they understood what the responsibilities were under the Fair Labor
Were they in
Standards
favor
Act.
of it or against it?
So as we were listening
Oh,
to
my
them,
heavenly
we were,
days. Never mind, because we're not going there. Let's go on to another question that we can answer, right? And I'm going to share with the American people, if you get somebody who's in charge, especially in a government entity that can't answer a question, you should ask yourself, do we need to replace this person who can't answer a simple question? I mean, my goodness gracious, the disappointment that I have that you can't even answer a simple question is unbelievable. Yet you want to be in charge and you want to tell the very people who you have no clue about their business what they can and can't do. That to me is repulsive. But anyways, enough of my opinions. Why is the DOL focused on crushing the economic opportunities for a sector that employs 64 million people and, get this, nearly $1.3 trillion to the U.S. economy? Do you believe in entrepreneurship? Wonderful. Then how does this law incentivize entrepreneurship?
So this regulation specifically protects workers who are in business for themselves, and particularly
by making it more difficult for them to do business? How does that correlate?
So this regulation specifically identifies for purposes of
I would
implementing the Fair
disagree,
Labor
the
Standards
truckers
Act.
would disagree, the independent contractors would, the people that actually do the job, other than you that sit up there, have no answers to any questions but want to pontificate on what you think is in the best interest of a sector that provides jobs for 64 million people and contributes $1.3 million to the economy. Critical. I'm sorry, Mr. Kiley, I am out of time and I yield back.
I'd like to thank the witness for taking the time to join us today, and I now recognize Ms. Omar for a closing statement.
Sorry about that. Thank you, Mr. Chairman, and thank you, Administrator Lumen, for your testimony today. While committee Republicans have spent their time trying to roll back worker protection, the Biden administration and congressional Democrats have prioritized building a stronger economy for all. The proof cannot be overstated. Almost 15 million jobs added since President Biden took office. Wages and salaries have grown faster than prices since the beginning of 2021. And the last 3 years have seen the highest level on record for new business formation. Progressive policies are not only good for workers, but they are also good for business. In contrast, we are halfway through this Congress, and Republicans have done nothing meaningful to lower costs or protect and uplift workers. Instead, they have proposed $7 million cuts in wages to the wage and hour division's already constrained budget. And on this very committee, Republicans have tried to undermine Acting Secretary Sue, halt the Biden administration's pro-worker agenda, and chase after unfounded cultural war conspiracy theories. Meanwhile, children are losing their lives working at slaughterhouses and other dangerous workplaces, and millions of dollars are stolen annually from workers' hard-earned paychecks. Congress must shift its focus to support, not obstruct, the wage and hour division's progress to deliver for workers, children, and families. We cannot afford to go backwards. I urge my Republican colleagues to join Democrats in fighting wage theft, securing paid leave rights for all working families, and ending the scourge of forced labor. I request unanimous consent to enter into the record multiple letters from the National Electrical Contractor Association, the Sheet Metal and Air Conditioning Contractors National Association, the Construction Employers of America, and the Laborers International Union of North America, in support of the leadership and policies of the Wage and Hour Division that not only uplifts workers, but ensures a fair and competitive economy for all employers. Thank you.
Without objection. What we've learned today is that we have a division, the Wage and Hour Division, and more broadly, a Department of Labor, that is spending more money than ever, is doing a lot of things that don't need to be done and that are actively causing harm, like this new incredibly disruptive independent contractor rule, but then is failing to do the basic things it's supposed to be doing, such as combat child labor and protect the rights of workers. And so, this Department of Labor has truly become an anti-worker organization in the current administration, and especially since Acting Secretary Sue took over. So if you're an American just looking at this department and all of the tax dollars that go towards it and asking, what am I getting here? This is what they see, that we have an unconfirmed acting secretary who has been there now for almost a year in that capacity, who the president is keeping there even though the United States Senate has rejected the nomination. On top of that, we have the department spending more money than ever and now requesting a 31% increase this year in funds. We see that the child labor crisis flowing from the activity at the southern border is not being addressed in any meaningful way from the testimony we've heard today, and the levels are absolutely beyond anything that we've ever seen. We see that the actual collection of back wages for workers has fallen significantly from the last administration. And then instead of focusing on those very important matters, such as protecting the rights of workers and combating child labor, what is the department spending its time on? What is this division spending its time on? On going after American workers, on trying to upend the ability of Americans to make a living on their own terms. That's what this independent contractor rule is going to do. The Chamber of Progress estimates it's going to cost more than 3 million jobs. And that's not speculation. We already have seen this play out in California with AB 5. This is the law that President Biden called his model. And there was a study that just came out of George Mason a few weeks ago showing that AB 5 led to an over 10% decline in self-employment in California and an over 4% decline in overall employment. Those are just numbers. I'd suggest taking a look at the stories of folks who have worked their whole careers to become a writer, to become a translator, to become a court reporter, to become one of 600 other professions, and then they just lost it all. They lost their career because of a law. And now this administration, this department, is trying to do the exact same thing to the entire country. So this is why Americans increasingly are pessimistic about the state of our country and the state of our economy, is because of actions like this. And this department needs a course correction. That starts with replacing the unconfirmed, record-breaking acting secretary, Julie Su, with someone who can get support from the United States Senate. And it also starts with withdrawing this independent contractor rule and looking at every rule and regulation and asking, how can we actually support workers and get our economy back on track? Without objection, there being no further business, the subcommittee stands adjourned.